Ready to take your verdicts and jury selection to the next level? Jury consultant Harry Plotkin and trial lawyer Dan Kramer are your ticket to tipping the scales before trial begins. You're not just picking a jury, you're picking justice. Produced and powered by LawPods.
All right, welcome back to another episode of Picking Justice. Really excited for this one. This is going to be an awesome topic, which we'll get to in a second, but I am currently waiting on a jury to give us a verdict. Harry and I picked a jury about 3.5 weeks ago in this case, and it's been kind of a slog, and we'll find out hopefully tomorrow what that verdict is. But it was a tough slip and fall case, and I'm sure we'll talk about it at some point on these shows, but learned a lot from that jury selection. It took about 3 days, but got some interesting people, got them talking about interesting things. So it was fun, Harry. I had a good time with you.
Yeah, no, absolutely. Yeah, I think we did the best we could. I mean, we picked in a tough venue for LA, and I don't know, I think we got like 18 cause challenges, and I feel like we still needed more. Not that we're going to get any more, but I still feel like it didn't get rid of everybody, so that was bad. So we definitely used our peremptories. Sometimes you get a tougher jury pool than others, so hopefully the folks we went with are going to see the light. Yeah, but totally excited to have Pat Salvi on today from Chicago, where I'm sure every jury pool is amazing in Illinois. You don't have any bad jury pools there, but but we're going to be talking about, because Pat does a ton of med mal. He's had some huge, enormous verdicts. I mean, he's had, a $400 million+ verdict, but we wanted to really talk to him about how you handle voir dire against popular defendants. You do a lot of med mal, you're suing a lot of doctors and hospitals, and obviously people love doctors and they love hospitals and they appreciate the care. And, the same thing applies to when you're suing, police departments, and, people appreciate police. Or if you're suing, out here, everybody loves Costco and Trader Joe's. I mean, it's the same issue when you have, so what do you do when,
or if you're suing the grandmother who rear-ended your client, I mean, those are like, that's one of the toughest ones to do. But this is a great topic. I think this is awesome because all of us have defendants we go up against who are really nice, likable, juries like them. So, yeah.
So obviously, the first way to deal with that is just to not sue any popular defendants. Pat, why do you still sue doctors anyway, despite the fact that everyone loves them?
A real disgrace, Pat.
Well, thanks for having me on, and good luck, guys. I hope you get the verdict you deserve. It sounds like it'll hopefully go well. Yeah, why do we do it? Well, our firm has definitely developed, I don't know if the niche is the right word, but we've definitely developed that niche. That's what the cases are. So certainly in medical malpractice, perhaps some of the most challenging aspects of it are who the defendants are. They're smart. They have access to the best experts. They're well regarded in the community frequently, as you just described. So it presents challenges, but not challenges that can be overcome. I think early in my career, when I learned tough lessons and got my teeth kicked in, I felt like you can't win malpractice cases at trial. It's impossible. But I think when you develop a number of skills from beginning to end, certainly not the least of which picking a good jury and overcoming, among other things, the things you both just described, the likability, kind of the inherent likability of the defendants, right when you step foot in the courtroom. Once you learn some tricks of the trade, you can overcome those with a good case. You got to have a good case, you got to have good facts, but even that sometimes doesn't do the trick in medical malpractice. So picking a good jury is a prerequisite to a great verdict, as both of you well know. So looking forward to talking about, some of those issues.
Do you guys do many openings in Illinois?
I'm of course aware of the concept. It's a very interesting concept. I've read about it. I've never gone forward with asking the judge to do it. I think probably because I anticipate the answer would be no. So I've never asked, and it's not in our Supreme Court rules, and it's not something I've ever heard done in this jurisdiction, in Cook County or anywhere else. I'd be very interested to hear some of the persuasive arguments to, allow for that, because I'd love to do it.
But you do, doing a little spiel before you get started on the questions is kind of the same thing. And I think if you don't have a mini opening, I think judges do usually give you some latitude in saying, hey, let me tell you a little bit, maybe not a little about the case, but you get to throw in little nuggets here and then. How do you start out your voir dire when you're suing a doctor, not necessarily one that everybody on the jury is going to know, but just the fact that it's a doctor and people like doctors? I mean, what do you say first when you're saying, hey, we're here suing this doctor. I hope you give me an open mind about it?
Yeah, it's not the first thing I do out of the box. Out of the box, as they say, you only get one chance to make a first impression. So I try to come out at the beginning and make some sort of a connection with the jury. Usually they've just heard that it's a medical malpractice case. There's been a catastrophic injury or a death, and if they're picked, they're going to be there for 2+, 3+ weeks. And I'm sure, and then certainly not the least of which, they're there to answer questions from strangers in front of 50 other people, which is most people's most dreaded thing. And so I try to connect with them on that in some way right out of the gate with a little bit of levity and understanding. And I talk to them about how powerless they might feel now, but how powerful they will be if they're impaneled on the jury and how important the case is. So I try to then take that concept and then start to empower, start that process of empowering the jury, which is critical in malpractice. So not to skip ahead too far, but certainly you need to get out in front for these jurors and say, hey, look, some folks think that, not having gone through nursing school or not having gone through medical school and a residency or a fellowship and having the training of a doctor or a nurse or other healthcare professional means that you're not in a position to pass judgment on them. Who feels that way even a little bit? And so making sure that with questions like that and others, you're making sure that you're getting people that have that courage and make them feel like they're courageous in so doing and theming that as well. And then early on, I also want to, assuming I'm not time limited and need to be more selective with my topics, I want to hear from jurors as to what's important to them. So I'll just ask them, what do you love? What do you care about? Could be anything, personal, professional, family, hobby, anything, and get them talking. And then it's after that kind of warm up that I dive into the malpractice aspect of it. And certainly, and I imagine we'll talk a little bit more about it, certainly I try to structure my voir dire almost like a case where my concepts are liability. My concepts might then transition to causation issues. Before I start talking about damages, I've already covered liability framed issues so that it doesn't seem, you don't want to seem like, we're just here to collect a check. You guys are going to give us a check, right? Then I go to the damages issues, but before I get there, I ask if anybody has experiences, and we can talk more about this, similar to the plaintiff, before I go to money. So I structure it in a way that's almost like the case, and then that first part after, kind of a warm-up is when I take on malpractice, really head on, where I try to expose those prejudices that might exist against malpractice for a variety of reasons. And there are a variety of reasons as to why people might not like malpractice cases.
One thing because I want to break all this down. This is good. You say this juror empowerment question or concept. Can you give us what you actually say when you do this? You feel powerless now, but you will have a tremendous amount of power. I like to hear that. Like, what is that?
Yeah, sure. So very early on, I'll give you two different sections that I like to do. Both of them are towards the front. This is very early. This is kind of like literally at the beginning, where I'll say, hey, look, you may feel powerless now. You got a summons a few weeks ago and it told you to come to, this courtroom at this time. And then you got here and you were sent to a room with all the other jurors, and then you were kind of herded around and sent to this floor and sent in here and asked questions from a stranger. You probably feel pretty powerless right now, but I assure you, if you're impaneled on this jury, you're going to be the most powerful people in Cook County because you're going to decide this case. And then not long after that, I'm asking them, who here has any concern about whether or not you can call out a doctor for not doing his job? You're willing to do that in a variety of ways. I'll try, I might call on somebody if there's someone I have a concern about. It might be in the context of anybody here have a close relationship with their doctor. Folks like that, not always, but by virtue of having a close relationship with their doctor, might be a tough plaintiff's juror, someone tough to convince relative to the standard of care. Another question I'll ask, which I think is very enlightening, is, if something bad happened to you or a loved one, would you investigate a malpractice case? Or are you the type of person who says, you know what, I'm not litigious, I wouldn't do that? That can reveal a lot, because people raise their hand, they'll say, I'm not that type of person, and they might reveal biases against your plaintiff. Of course, they have done that. They have investigated a case and brought it all the way to trial. So those are some of the ways relative, in the first third or so, I'll start to try to identify biases against malpractice cases. And another thing is, we have a lot of reasons, among them why people may not like malpractice cases. They have a perception that it drives doctors out of the state and makes healthcare less available. It reduces the amount of individuals interested in going into healthcare, so it's responsible for a shortage of healthcare providers. Or it drives up insurance rates and thereby drives up healthcare costs for them. And so those might be some of the reasons they're biased against malpractice, even though we could do entire podcasts on why all of those things aren't true.
Do you bring those things up yourself, or do you wait to see if a juror raises that and says, hey, it makes healthcare more expensive, it makes my rates more expensive, it drives doctors? I mean, do you actually ever bring that up yourself without the jurors bringing it up?
I do. And so frequently I'll start with it open-ended and see what responses you get. You know, sometimes people, as you know, they're being shy, they're not sharing. And then other times I will just put that out there. I don't believe that a juror who's going to be, say, neutral enough to where they'll give me a fair trial, or is plaintiffs oriented to where they're likely to be on my side, I don't believe that that type of juror is going to hear that and say, you know what, I never thought that before, but now that he's mentioned it, I believe that. So in essence, I don't think that's poisoning the well. But I think a defense juror might be given a little bit more encouragement by me saying it to raise their hand and say, you know what, I have read that and that concerns me. And then once you get a hand, it's always good to ask if anybody else agrees with, Mr. Smith, and then the floodgates hopefully will open on those folks who have biases and perhaps will say something that you can get them for cause. So I don't think that poisons the well. I think really the only thing that might poison the well is if somebody said, I know Dr. So-and-so and she's the best doctor and saved my, mom. That's a problem. Then I'm going to ask for a new veneer. But stuff like what I just said, I remember recently in a case we had a radiologist who was in our veneer, and she was an easy cause. She wasn't even trying the subterfuge, right? She was out and open with her biases. I can't be fair. I'm going to side with the doctor. And she started talking about how malpractice cases take resources away from other places that would be better served. And that's a great opportunity. It did not faze me. I wasn't nervous. I didn't think it was going to have an impact. That was a great opportunity to turn to the rest of the jury. Thank you, Dr. So-and-so. Turn to the rest of the jury. And does anybody else agree with that? And get more open responses from people. So to answer your question more directly, I will put it out there.
I really like your question on if this happened to you, are you the type that would investigate or file a claim? I think that could apply obviously to any case. In a PI case, if you slipped and fell, do you think anyone here would or wouldn't, file a claim or file a lawsuit or hire a lawyer or car crash? I really like that because it really personalizes it, and then you're going to get a wide range of responses. Like some people may say, yeah, I mean, I maybe would, but I'd only want my medical bills. I don't want like the pain and all that. And then you're going to get a lot of insight there. But I think it really makes them think deep about it. And I think you're going to get a lot of good information. I'm going to steal that, Harry, in our next trial.
And as you know, Dan, the answer and the body language can, both be as important as the other. So yeah. You'll get plenty of people that are like, oh, absolutely. Because for whatever reason, they kind of have this, they came into court thinking like, I'm going to fight for my rights, whatever. I'm not going to hesitate. And then you get people that you need to be more concerned about, of course, that are like, oh no, I would never do that. And we've heard this, I'm not that type of person. And that's a red flag.
Well, we had a guy, day 3 of this trial, we're waiting for a verdict, and he was like the CEO of a company wearing like real fancy sweats and a fancy watch. This guy, I was like, this guy just looks like a prick. And at first I thought it was gonna be good for us, but then he just started, he's like, I really believe in the legal system and the power of a jury, and saying all these things that I usually say in closing argument. And he's like, but these cases are fucking bullshit, like just on the record. And he just goes off. Like he just is like, this is just so ridiculous. I don't think a landlord should ever be sued. They can never be negligent. And then like some other jurors that I was a little worried about, they start making like weird faces towards him because he's going so extreme and so aggressive. It was kind of funny to watch, honestly. He was just such an asshole, like this super rich dude who just like hated any of these cases.
It's so fun to watch when someone says something way out there, you can learn so much about the other jurors to see who's just shaking their head and who's nodding and who's like rolling their eyes. It's super interesting. I love it when they say that, because then I'm just looking at everybody else, especially the people that we already voir dired, because you're getting more information from them.
And we did from that juror, juror number 7, quote unquote. She's one that we really have liked, and I started liking her because she made this really like, this guy's crazy kind of face, and she was like right behind him, and I totally saw that. I was like, okay, we got to keep her. She'll be good.
One thing that you said that I love, and it's the same kind of approach I do in med mal cases, especially, and police cases, which is the most important thing that for me is, are these people going to be able to second guess a doctor or a police officer? Do you think that you're smart enough that you could actually overrule them, even though you've never been a doctor? You didn't go to med school, or you didn't go get police training? Because I found that only those jurors who are like, I think I'm as smart as a doctor, like, can do that. And but the unique thing about it is, you never have to ask that question in like, a trucking case. You never have to ask that question in like, landlord case or against an employer. Like in those cases, people don't trust doctors and police officers. They don't put them, they do. They don't trust them as much as they do, but people put police and doctors up on a pedestal so much that people are like, hey, they're doing their best, and they're so important. And so how could I ever second guess their judgment? And it's something that if you guys at home are trying a case against a really well-respected defendant, you got to ask those questions, even though you don't ask them in most of your cases, right? Because, and one of the things that I like to do in like med mal cases, I don't know if you do a variation of this, Pat, is kind of one of the first things I like to have the lawyers I'm working with ask is like to say, hey, even for me, when I hear that a patient suffers a bad outcome, my first reaction is to assume, the doctors tried their best. How many of you feel that way too? Because I think in police cases and med mal cases, you have to show everybody on the jury that like, hey, I'm not some doctor hater. Like, I appreciate doctors just as much as you do. It is normal it's not biased just to kind of first say, oh, I assume a doctor was trying their best, but can you get past that? Is there anything that you tell them to kind of build a little credibility about doctors, but get past it?
Yeah, I think that, I do a couple of things. I think, first of all, I arguably go overboard, but make it very clear, because we know what's coming once the defense gets up, at least to some degree, in terms of, they've got to meet their burden and no sympathy and things of that nature. So I want to get ahead of it. And part of the intel I do is I'll read voir dire from the defense lawyer if I haven't had a case against them before. Or even if I have, and just get a flavor for what they like to ask, and then at least for some of them, ask them first, and then see if they're nimble enough to avoid the repetition, because that's a good way to throw them off and kind of steal credibility from them, because you're asking the defense questions. So more directly, I think what I try to do is, whenever there's a moment, and these moments come up where the concern is that either something you said or the way voir dire is going, it's almost like, there's an assumption you're going to win, and you pause and you say, if we prove it, assuming we prove it, everybody understands, just please by a show of hands, we have the burden of proof, and if we don't meet it, then it's going to be a verdict for the defense, right? Everybody agrees with that. And you do that, once or twice with a variation on that, to try to garner credibility in that regard. I don't know if I can say that I have a specific question that goes more towards like, hey, I like doctors too. I'd have to think about that. I'd want to balance gaining credibility with kind of participating in the propping up of doctors, because actually what I really want to accomplish is I want to bring doctors down to everyone's level, so that everybody's like, yes, I can sit in judgment of a doctor. I like the way you phrase it. I haven't done that, and I might steal that. When you said, can you overrule a doctor? I like that. That's cool phrasing that I might steal from you, Harry. Something like that, so that everybody starts thinking like, A, I can do it, and B, if I do it, that's courageous. I'm being told that I have power, that it's courageous, that it's hard, and yes, I'm up to the challenge. I think that's the feel you're going to get from people that aren't going to shrink to that challenge. And really the concern is, if you allow someone onto the jury, say you miss them, say you run out of perempts, you couldn't get them for cause, whatever, and you have a defense-oriented leader on there, and that's going to be your biggest problem in deliberations. Well, people that are weak are just they're gonna go with that, as we know. And so we want people that are courageous. And you know what else? And I know you didn't ask me about this, but we just took a verdict yesterday, not me personally, but our office did, and we got a nice verdict in a malpractice case. I think, one of the keys, relative to the jury is that, you have these folks that feel as though they have good bullshit radar, because every malpractice case, you're not always going to have a profits over people motivation. You're not always going to have a driver that was rushing because of something else, or some kind of very high level values driven reason why the injury occurred. A lot of times it's the doctor screwed up and you don't really know why. And so how do you get them angry? Well, it's in weaponizing the defense. And so you want jurors that have that bullshit radar and are willing to call that out. And so this is you're kind of getting those types of jurors with these questions as well, because inevitably during trial, you're going to need them to hear something from the defendant who's going to say it with a smile and with all their degrees and everything. And it's going to sound good and it's going to contradict other stuff. And you're going to need these jurors and be like, that's bullshit. They have no credibility. I'm not going to give them credibility. That's such an important aspect of malpractice and the type of jurors we're looking for.
Do you ever go into, judging the act, not the actor? Because say you have a doctor that's just this, really well respected, great credentials, never really been sued before. Will you acknowledge he's a great doctor, he or she's a great doctor, they messed up, or there was a bad act? Do you address that in jury selection ever?
Yeah, if that's the situation, and it's not infrequent that it is. We had a guy recently who we went to trial. We settled the night before closing for a favorable figure, but one of the reasons we did want to settle was he was a likable guy, and we had a good case, but he was a likable guy. He had been, he came across as likable and caring. He had been the president of the medical staff or the chairman of the medical staff at the hospital, which is a position, you only get if you're a good politician and you know how to talk to people. And so under those circumstances, Dan, I'm not sure I would go quite as far as kind of literally what you just said, more along the lines of, this isn't about whether so-and-so is a good doctor. It's about whether he was reasonably careful under these circumstances. And so if that's a concern, which, frequently it is, so it probably is something you could ask in any malpractice case. You do it in voir dire, and then you can do it again, maybe in opening, but certainly in closing if that remains a concern. And hopefully that gets any, fence-sitting, plaintiffs-leaning jurors, not to worry. It's not about whether someone's going to lose their license or be able to continue to practice. Nobody's going to jail. It's not about whether he's a good doctor or a nice guy. It doesn't matter. Just like sympathy doesn't matter, that doesn't matter. It's whether or not he was reasonably careful under these circumstances. I do think that's important.
So Pat, one of my concerns is that because, jurors feel like doctors do so much good, a lot of times I hear them say things like, they're only humans, they make mistakes. And the concern is always like, well, if somebody does so much good, why are we punishing them for making one mistake when these are, they're saving lives, they're doing these things? How do you I'm sure you hear that a lot. How do you handle it when you have a juror who says they're human beings, they're not perfect and things like that?
Yeah, I mean, that's a juror you're going to be exploring cause challenges and maybe saving a perempt for, no doubt. We've touched this a little bit, the balance between propping them up as kind of a shield because you're concerned about that. You want to make sure the jury's focusing just on these circumstances, not giving the doctor a pass for past good deeds or for having great credentials or being a nice and caring, seemingly fellow. And so that's a challenge, I think, in jury selection. And so the jury you just described, you've certainly, hopefully, flushed them out and then explored various avenues for cause to avoid having to use a perempt. Certainly, and I know our focus is jury selection here. Every time you think of a good idea in closing, there's a way to package it in voir dire. And so in closing, certainly, if I've said it once, I've said it many, many times, this is what they're paid to do. And you try to get beyond this, idea that they're volunteers and from the time they wake up till the time they go to bed, all they do is obsess about caring for their patients. Because we know under the circumstances of this case, they did not act reasonably careful. So this is what they're paid to do is something I'll certainly say in closing argument. And something interesting that I really haven't done in voir dire, kind of along these lines, is a question kind of like what you just posed, designed at getting after jurors that may feel as though past deeds should mean they don't have to stand trial. You mean 40-year career and you're negligent once, and here you are potentially liable for tens of millions of dollars or over $100 million, which I've, voir dired on a few times in malpractice cases. Yeah, those are biases that need to be exposed. So,
and sometimes they'll say, right, just because a doctor made a mistake doesn't make them negligent. They weren't trying to, I'm sure you got that all the time. People who would say, I could only find against them if like they intentionally did something, which is a standard you never hear jurors say about any other kind of defendant. I worry that some plaintiff lawyers would hear a juror say, hey, they're only human, they make mistakes, and think, oh, that's a good juror because they acknowledge that doctors make mistakes, but it's not. So,
a key there is that, so the magic words, as we know, or at least in our jurisdiction and in many others, is reasonably careful. Did the obstetrician act as a reasonably careful obstetrician under the same or similar circumstances? That's basically the instruction in Illinois. Reasonably careful is much better than negligence or malpractice, which seem much harsher. And so by using reasonably careful with the juror you just described who is looking for intent might be an avenue for cause. And so then you explore, well, let's say the plaintiff did prove that the doctor did not act reasonably careful, but did not have intent to injure or reframe whatever it is the juror said, reckless or with intent. Would you be able to find for the plaintiff or something along those lines? And maybe you get a good answer that disqualifies that juror, and you can then open it up to the rest of your panel to see if anybody agrees with that juror. So if you start to hear words like that, I think, like a shark with blood in the water, there's a cause challenge out there to go get.
For sure. And I think you have to follow up on when somebody says they're only human, they make mistakes. And then you say, okay, so what? Yeah, you have to
lean
say,
into it.
Yeah, you got to say, so what does that mean? I mean, if a doctor does make a human mistake, are you okay? Are you comfortable? Or is there something that you feel like is unfair to hold them responsible in a case like this? And I think a lot of them will say, yeah, that's what I'm saying. I mean, everybody makes mistakes but you got to, I think, push them to put into words what they're feeling, because there can be a lot of cause challenges there. I think if you push them, for sure. And then another thing I like to do with that, certainly spend as much time as you need, as many jurors that might raise their hand that agree with that juror, to get as many of those cause challenges as you can. And then in terms of theming and getting back to putting those thoughts into the minds of the jurors that will be on your jury that are favorable for how they're going to, digest your case, you turn and you say, well, and who might think otherwise that, no, if a doctor does act in a way that is not reasonably careful, that there should be accountability and that the person harmed should be compensated for that, or something along those lines. Someone says yes, you can ask them, tell me more about that if they're kind of short with their answer. Throw a devil's advocate question at them, like, well, but you did hear Mr. So-and-so talk about how, they're human, and after decades of good work and many years of training, they make one little mistake, but albeit negligent, that they should get a pass. How do you feel about that? And in my experience, almost invariably, they dig in their heels. They stick to their guns on what their answer just was. They probably give you more good content that you can repeat back in closing argument, which is another thing I love to do. Take sound bites from jury selection and package them for closing argument. So that's a good opportunity to also start theming, which is kind of essential to what the focus of our discussion has been today, which is how do you get people to hold doctors accountable despite all of the kind of outside noise that sometimes prevents them from doing so.
So that's the liability. And you said you also do voir dire on causation, right? What does that look like?
Yeah, sure. And it's a little case dependent, and it's a little bit more along the lines of, and it's also judge dependent, the burden of proof. So a lot of times prior to attorney questioning, the judge will frequently do kind of the, don't worry about what you've seen on TV. This is a civil case. It's not beyond a reasonable doubt. It's a preponderance of the evidence. It's what's more likely than not. And I'll come back to that. And that's not really going for cause challenges, but it's. Oh,
sorry. I meant causation. Yeah. Like.
No,
yeah,
I know.
Okay.
And so for causation, yeah, and I kind of talked about burden of proof, and then I can kind of link that to a cause. So we have a pretty good cause instruction in our in our jury instructions, our proximate cause instructions is along the lines it needs to be a cause, does not have to be the last or nearest cause, does not have to be the only cause. It can combine with other causes that in the natural and foreseeable course of events. Along those lines. I'm close, maybe not perfect. And so it's good because it really does say a cause. And so in closing argument, I'll have a flip chart where it says at the top, any negligence, and then a line, a cause, and then a line, full damages, to really highlight the concept that, hey, we've got 6 allegations. We don't have to prove them all. And it only has to be a cause of the injury, not the cause or the primary cause. So really all I'm doing there is it's not a cause challenge focused section, but I'm touching particularly and frequently a lot of causation challenges in malpractice cases. I'm hitting the issue so that they're starting to get an understanding that it's a cause. And that's something I'm theming from the beginning to the end. Now, some judges are very reticent to let you go deep into instructions. So there's a latitude between, a spectrum for judges as to how far they'll let you go. But if I'm getting some latitude, I'll really push it and I'll start asking, well, let's say we only prove that it's a cause and there's a bunch of other causes. Do you think you would be able to find for the plaintiff if we did prove it was a cause, but it wasn't the primary cause, and get people talking in that regard?
I imagine you have a lot of people that talk on that exact question. I imagine you do. I mean, you probably have a lot of the ones that may be good on that may be good on liability, right? Like I'm fine to hold the doctor accountable, but if you're telling me what they did was combined and wasn't even the main reason for the cancer or the amputation, whatever it may be, what's the feedback you usually get? What are the responses you usually get to that?
Yeah, I would say it's probably 50-50. I'd have to go back and look at transcripts that I get cut off before I get to that. Yeah. Judges sometimes think you're going too far on the law there. But I think actually the way I just phrased it is probably appropriate. And so I think the responses are, a lot of times, particularly when you reframe it that like, well, that's the law, they'll say, if that's the law, I'll follow the law. But then when you get other folks that start saying that, I don't know about that, then your antennas go up, and you do get that. It seems unfair that if it's only a minor cause, does it need to be the main cause? And you say, well, let's assume for a second the law says it doesn't need to be the main cause. It just needs to be a cause. Could you follow that law? And if someone says no, boom, they've disqualified themselves. I think it can be helpful in one of the various ways to expose defense-oriented jurors, because that concept is clearly if that's how you're thinking, you're clearly a defense-oriented juror. And then absent, like, let's say you have someone who everything else seems pretty good. They didn't give you a great answer on this causation question, but you followed up with, if the law says that it need only be a cause, can you follow that law? And they say, yeah, if that's the law, I'll follow the law. I don't know if I don't know if I need to use a peremptory on that person, but it might be an opportunity to get a cause challenge on another defense-oriented juror if they stick to their guns on that.
Yeah, like you said, let alone just planting that seed in the jurors' minds, because I think that is more of a foreign concept that, the law allows for multiple causes. I think planting that seed is really important that early, even if you don't really learn a ton or get a cause challenge, like you said.
All right. So want to thank our sponsors again. The first one is Verdict Videos. Kelly Deutsch. If you don't know Kelly Deutsch and Verdict Videos, welcome to the plaintiff bar. I know that, for Dan and myself, we work a lot of the same cases. I know for my wife and I, we have focus grouped their videos in focus groups, and jurors have loved what they've seen of these things. I've seen the increase in value, and the settlement value of these cases is sometimes tens of millions of dollars more after the jurors watch their settlement doc videos or day in the life videos than before they watch the video. And day in the life videos, I don't know if you use them, Dan, but they're not just for trial. Settlement videos for mediation are an effective tool for trying to settle cases pre-lit too. I'm sure you use both of them.
Yeah, the best thing about working with someone like Kelly is that you're not handed off to some, other person, or you're just dealing with projects. Like you will get Kelly's cell phone. She knows how to talk to clients, and I think that's one of the hardest things when someone's to be invited into their home. She'll talk to the client. She'll sit down with the client. She knows how to tell a story, and she's just such a wonderful person, like truly empathetic, compassionate. She really understands what a client's going through, and that shows through in her production. And she's wonderful. We love her. She's just she contributes to the community. I know through LATLC, the charity, and all that. She's just a great person, very easy to work with, great pricing, and really will add a lot of value to your cases.
And I know what a lot of lawyers that I talk to love most about Kelly in verdict videos is they are always honest about whether they can help or not. I know there's cases where she has said, I don't think I can in this case, but I know that she's told me, our motto is video can hurt you as much as it can help you. And so I know she is actually cares and is strategic about how she can help in these cases.
Which is very true. I think in general, like everyone's like, oh, I need to have the best animation. I need to have this, that, and the other thing. Sometimes less is more. And again, it's great. It's important to work with vendors who are going to be straight up with you and who are going to be honest, like Kelly, and not just want your money from the case. Like she will be straight up. And those are the best vendors to work with. Another wonderful sponsor I'd like to thank is my dear friend, Melissa Baldwin from Baldwin Settlements. She is a structured settlement broker. She's fantastic. She's one of the first people I met when I became a plaintiff's lawyer, and has just given back, just great advice. She's another one of these people you can call and just, get some advice, and she'll really go out of the way to help you out. She supports CAOC, CALA, all the, AAJ. She's a huge sponsor of all these organizations. Her and her structure team work tirelessly with the attorneys and clients, and she really makes the hard fought result easy for the client. I mean, I had a very tough case from someone who was basically homeless, and she was able to make him understand he did not have any education to speak of, barely spoke English, but get him to understand how important it was to structure the money, because a lump sum and the many millions of dollars just would not have been good for him, given he had some issues with drugs and all that. She was able to speak to him at his level and get him a structure that really set him up for the rest of his life. And she was willing to work day and night, anytime, weekends, just to help get it done and get the best rates she can for the clients. So, and she also does not just structure. I used to think, I'd be like, look, when I was just starting out, my cases aren't big enough for you, Melissa. She's like, no. Like it's not just for the 7-8 figure settlements. It's really for all clients who just need some help to structure. And she can also structure fees, which is great if you want to put a little bit away for yourself and your family later on. So call Melissa Baldwin from Baldwin Settlements. Really great person, great friend. These two sponsors are just wonderful women that I really respect, and they run great businesses and good people. And lastly, we just again want to thank LawPods for making this possible. These podcasts, their whole library of attorney podcasts, truly help, all of us get better. And I highly recommend you just listen to them. I put them on the car. I'm listening to all these trial lawyers throughout the country with all the experiences they have. And it's just such a great avenue, because we can't make it to courtrooms all the time, but we're hearing from the best. So thank you for LawPods for providing that platform. So let's talk about, I'm really curious how you broach the concept of money. You've obviously gotten, crazy 9-figure verdicts. How are you talking about it? Are you bringing up that much money this early in voir dire? Are you kind of slow playing it? I'm curious, like, what your first transition into the discussion of money is on these cases.
Yeah, so they've heard the statement of the case, right? They've heard some of the not preliminary, but the questions that we've kind of gone over, liability, maybe a little bit of causation, and they know a little bit about what the case is about. They particularly if it's an injury case, they don't know a lot of details yet. So let's stick with an injury case. If it's a wrongful death, that somewhat speaks for itself, and there aren't too many options here, although there might be some. But with respect to an injury case, one thing I want to do is I want to explore, for a number of reasons, perhaps the 3 to 5 worst aspects of my client's injury, to see if any of the jurors have any experience with it. Typically, they wouldn't have themselves because these are bad injuries. But of course, a loved one or someone close to them, if they have any experience with someone that has that is paralyzed, confined to a wheelchair, that has neuropathic pain, that has difficulty swallowing, that has a tracheostomy, that has a colostomy bag, that has to be fed through a G-tube, whatever the worst aspects of the injury are, I want to ask about it, because I think it's important to know that. Frequently, the things our clients are dealing with are so bad that most jurors have no experience with them, which is probably preferred. And, when someone does have an experience with them with something similar to what the plaintiff's experienced, then you got to explore that and see how that might shake out. But then, at least at that point, the jurors have heard this. I don't say, because I would say it's probably technically improper, although I know a number of plaintiffs' lawyers might do it this way, and I probably have phrased it this way in the past, but nowadays the way I ask it is along the lines of just, has anybody experienced this, versus you're going to hear evidence that the plaintiff has this. I don't do that. So, but they make that connection. They understand that there's a reason you're asking about these aspects of the injury. So then when you turn and you say, if the law and the evidence supports a verdict in excess of 50 million or 100 million or 100, whatever you end up asking, what you anticipate suggesting in closing argument, now they've got some context for it and they don't totally recoil. At least that's the idea. Now, I also think you should be suggesting an amount of money that perhaps doesn't cross the line, but approaches the line on whether or not the jury's going to recoil, because if you're not, then maybe you're not asking for enough. So you might get some jurors that respond to the specific money question. And another thing, to back up just one moment, I do the economic first, and then I talk about non-economic. So I want to understand any preconceived notions that might be prejudice against, particularly, as we all know, typically you get a more favorable reaction to economic. But then when you talk about non-economic, pain and suffering, disfigurement, loss of a normal life, as they're described in the jury instructions in Illinois, okay, now you've covered those. Then you go to the money question. Now, specific to malpractice and similar to police cases, Harry, because I know you've kind of drawn some overlap there. You want to ask, and if it's a police case, you're talking about a municipality. Now people are thinking about taxes. You ask that money question, and then you follow up with, even if it's against the hospital. Even if it's against the hospital, like someone says, yes, if the law and the evidence supported a verdict of in excess of $100 million, I could sign that verdict, even if it's against the hospital, and see what their reaction is there. Because just their reaction is going to be helpful. And, sorry to keep rambling. I'll pause in a second so you can ask.
No, this is great.
Do you ever have your clients, do you have them in the courtroom ever?
Great question. So lately, my philosophy has been, if you can do it seamlessly, I do like an introduction in jury selection. I typically don't want them there in jury selection, and that goes all the way through trial. Lately, the last few cases I've tried, they've been in the courtroom for a jury selection introduction where we kind of orchestrate it with the judge that there's going to be a break where they can leave, or maybe they sit there for the judge's question, and then when we take a mid-morning break, they leave. I don't want the jury to get desensitized to looking at the plaintiffs, and not that that's going to happen in one morning, but I don't want them to be focused on how they're reacting to things. There's no right way to react. If you react emotionally, it's too much. If you don't react at all, well, why, wouldn't I, if I were in their shoes, I'd react. I don't want them second guessing my client's reactions. So typically lately they're in the courtroom for introduction during jury selection, their testimony, and closing argument, and that's it. I do like having them there for closing argument.
That's exactly what I do. I'll have my client there, and then as soon as I start questioning, I'll bring up the brutal honesty stuff, and then I'll have my client walk. Most of my clients can walk out. I don't know.
Well, if it's a kid, if it's a kid, it's their parents, or if it's a death case, so same here. Yeah.
And then just have them come back for their examination and then closing exactly the same way. I don't think jurors, like there used to be the big fear, and we've talked about this in other podcasts, is that, jurors are going to judge your client for not being there when they have to be there. I just don't think that really comes into play very much. And I think the jurors are focused. The judge will often read an instruction you're not to consider whether they're supposed to be there or not, because the defense attorneys love pouncing on that. When I have other before and after witnesses, they did in this last trial, the judge shut it down, but they'll be like, well, do you know where Mr. Brown is? Where is he today? Why hasn't he been here the whole time? And that's like totally improper. The judge shut it down, called out the defense attorney, and then at that point, the jurors don't know. They've never been in this situation before. They don't know if they're supposed to be there or not supposed to be there. And so I think it's something I used to be weighing my head about and realize it's just not as big of a deal as I'm making it,
Yeah, and in malpractice cases, typically those defendants, they're there every day.
Same thing.
Every single day. And so what I do is I definitely ask the judge for an instruction. Your Honor, would you tell the members of the, not in front of the jury, but before they come out, will you tell the members of the jury that the lawyers, the parties, they don't have to be here the whole time? And gosh, 9 times out of 10, not 10 out of 10, 9 times out of 10 we'll get that. One way or another, whether we get it or not, that's a quick touch in jury selection. And I think it's disarming. It's like you ask the first question, you say, the parties and lawyers, including my clients, might not be here the whole time. Is anybody feel you might hold that against them? Typically you get no hands. You might, but typically you don't. And then you follow it up with, some of you may feel like, well, geez, we have to be here all the time. Why shouldn't they have to be here all the time? Particularly the people that brought the lawsuit. Does anybody feel that way? And again, usually you get no hands. But to me, to your point, Dan, it's pretty disarming in the sense that they're like, oh, okay, the judge told me, and or the lawyer's asking me. It's nothing, and then it's a non-issue.
Have you ever thought about turning around though, if the defense is like making a big deal of it, of saying like, because if you're suing a hospital, that's not the hospital CEO there during the trial. It's like some low middle level HR something. I mean, you could turn around and say, why wasn't the CEO here? Why wasn't the CFO here? Why didn't they send?
I've said that before.
I mean, if they make
I've
a big
done that
deal of it,
before
yeah.
in closing, it's probably improper.
Yeah.
It's probably improper, but I definitely.
Well, certainly if they bring it up,
Yeah,
right?
no,
Exactly. That's what I'm saying. Yeah.
I mean, the irony of the case that we got a verdict on yesterday, just I'll do a quick shout out to Matt Williams, Aaron Bader, my sister-in-law, Erin A. Salvi, and Melissa Gelibert. They got a $20.5 million verdict on a sad case, death of an 11-year-old girl. But one thing that was interesting on this topic, this was a situation where the judge would not give that instruction before jury selection because the defense objected and he just decided he wasn't going to give it. They voir dired on it. The clients were not there for at least some of the trial. They were there a little bit more than what I just described, but still were absent at some points in the trial. Get this, the nurse that was ultimately found negligent, she was there for the entire trial, except for whatever reason, we don't know why, closing argument, and yet the lawyer still kind of subtly jabbed the plaintiffs for not being there the whole time, the parents, which to me is an obvious one. Do you really want to sit there for a whole trial?
I would never
relive the worst.
That's crazy.
It's awful. It's absolutely awful. Obviously that didn't work. So
yeah, well, that's a great. Congrats on the verdict. That's amazing.
Yeah, I didn't. Maybe other than a little bits of advice here and there from the sidelines, I didn't do anything. The team did a great job. Yeah.
Yeah, it sounds like a terrible case, though.
No, it's so sad. Yeah.
Let's see. So you don't give the exact number you're going to ask for, or do you just say like 50 in the tens of millions, over 100 million, or what's your philosophy?
Yeah. So I had a situation back in 2018 where in a kind of a condensed period of time in just a couple of months, I tried 3 cases kind of back to back to back. And even though that is very anecdotal, the second of the 3 cases, it was a death case. I asked for, I think, $14 million, and we got $2 million before it was reduced for some contrib. And when I was talking to the plaintiffs-friendly jurors afterwards, they said that when they went into closing or when they went into deliberations, they were thinking like 5 to 7. They were kind of advocating for that amount, and that there were some defense-oriented jurors that brought it down. And so that got me thinking like, you know what? I'm not sure I had enough of an impact on their thought process before I got to closing arguments 2 weeks after voir dire and everything else. And so then we went into the third case of the triad back in the fall of 2018. Anybody who's tried a few cases successively, you're tired, but you really feel like your skills are sharpened.
Big time.
And I'm like, and in my mind, I'm like, I'm not letting that happen again. And so in that case, we voir dired on $50 million. So if the law and the evidence supports a verdict in excess of $50 million, can you sign that verdict? Everybody that ultimately was on the jury did say yes. Some judges will consider that a cause challenge if they say no, but some won't. Some of them hesitated, which, by the way, I don't think that's disqualifying. We had people that hesitate. That's okay, right? People that hesitated that later, happily, after they heard the evidence, signed the verdict. But the thing I love the most is I think my suggestion in closing was between like 56 and 59 million. And this awesome, blue collar guy, but savvy guy who was, making eyes with me during the course of the trial in terms of like, I'm with you. Like, these people are full of shit. He comes up to me after the verdict and he was great. He looks at me, he goes, that 50 million you did in jury selection, was that some kind of a Jedi mind trick? Because the verdict was 50.3 million. And so that experience kind of has, again, I understand it's anecdotal, very much informed my approach, and I try to be as specific as I can. I usually do it at a level where I'm going to go above it. Maybe I give myself a a little bit of wiggle room if the case goes really, really well. But once you kind of commit to that number, there is kind of a range that you're confined to. But to me, it's better to do that and live with it than to, at least from my experience, than to say millions or tens of millions, which can ultimately be a bad anchor.
Yeah, I mean, I think it is very dependent on, if it's a case where the plaintiff has these terrible things or a death. I think you get away in voir dire asking for that. Like in the case that we just tried with Harry, it's a terrible pilon fracture that led to CRPS. So bad injury, but it's not that obvious from the outside, right? I mean, my client walked in, he had a slight limp, but not really that noticeable at all. And, was able to walk out. So, and it's a slip and fall case. So we made the decision not to go with, like, in voir dire, if I had said, tens of millions or 30 million or 40, whatever I had said, then I think they would have all run me out, Harry, don't you think? I mean, if I had...
Yeah, I mean, I think you got to
sense.
do a lot of explaining if you're going to get it. I mean, and Pat, I mean, that's a great idea to talk to them about. Have you ever experienced this and list some of the things so they get a sense of what it is. But you have to, because remember, Dan, there was one guy who actually is on the jury. I think he was an okay juror, but remember he said, I just got to say there was a disconnect between, how much money you're asking for and me seeing the guy walk out of here just fine. And if he's saying that he can't work, and the reality is we're not saying he can't work. We're not saying, it's chronic pain. But sometimes jurors don't really get it. And so it's weird. It's one of those things where even though judges don't want you giving your opening statement during your voir dire, when you give them a number or you say millions, you have to sort of say either here's why, or, trust me, you have to somehow say, hey, this is what it's about. I mean, it's not just, obviously it's not a minor injury. Yeah.
No, but Dan, that makes sense. I mean, you have to calibrate how you're going to maintain your credibility, which is sacrosanct. And if there's a concern, you're going to lose it because the number's too big and the injury at face value doesn't justify it, then I totally agree.
Going back to the 14 million, are you thinking that, obviously they took that 14, the good jurors were 5 to 7, the bad ones were 2. Do you wish you would ask for more? Do you think you didn't ask for enough in closing?
So the one issue about that case is the decedent was in his early 40s, unmarried, no kids. He had, I think it was 5 siblings, all of whom were older, some substantially older, like into their 60s. And so they had a good relationship, but again, he's a busy doctor and it's not like they saw each other all the time. So, your evidence is your evidence, and it was a lovely family, but I don't know what a bigger ask might have done. It's certainly possible that might have helped. Yeah, did they take my ask and kind of cut it in half in terms of what they thought? So if I'd have done 20 or 30, would it have been a similar dynamic? I'm not sure. I think in hindsight, I wish I would have voir dired on in excess of 10. Even when I was doing voir dire, best I can recall, I was certain I was going to ask for more than 10. So I feel like I probably should have done that. And it was a left turn case with a truck is probably a little bit of an exaggeration, but a bigger vehicle and a motorcycle. So, you had motorcycle biases and that sort of thing, but it was a death. And so I wouldn't have had trouble, saying 10, in excess of 10 million. Yeah. But no, it's a good point, Dan. You might be right.
Yeah.
That's what we're always, the Monday morning quarterback.
Well, dude, I do that with all my cases. Like every year, my ask has gone way up, up every single year. Like even like a case from like 3 years ago, I'm like, God damn it! Like why did I ask for this amount? I should have asked for double. But it's what we do.
Yeah, I don't think there's a right way between, do I ask for a specific number? Do I ask for a range? I mean, I've seen both sides have their pluses and minuses. I mean, I picked a jury 3 or 4 years ago where we had a great jury. And I think in opening, the plaintiff attorney asked for $6 million. It was over a car crash and a back injury case. And then it went so well that I think he asked for like 7 or 8 in closing, and they gave us like 6, and they were mad at him. They were like, the only thing we didn't like is you told us it was going to be 6, and they didn't appreciate that he asked for more.
I mean, I do think overall, I think actually plaintiff attorneys don't ask for enough, frankly.
Yeah, for sure.
Even the most experienced ones, I think they're so scared. I think it's like, unless you're going to do something crazy like 300 million when someone's alive and can walk, something that's just so out there, I think it can backfire. But I think the line of when it backfires on you, it can cause a lower verdict is way higher than we think. I don't know. What are your thoughts, Patrick?
Yeah. And Harry and I just did a little big data, which can be very helpful in that regard. And so that's kind of a something to explore where you do the big data studies and you kind of push the envelope in that regard. But what you just said, I do agree. And I think the question we all have to ask ourselves is, if I ask for more, am I really going to get less? And really push the envelope and focus it, focus group it or do big data and try to find that balance where it's not sticker shock, but you're properly framing your injury. We call it anchoring, and there's, let's be psychologically, it's an anchoring concept. But at the same time, we as plaintiffs lawyers, we believe that the injuries that our clients have suffered are worth every penny that we're suggesting, because we know what they're going through and how bad it is.
Well, I think the best exercise, I know this is a jury selection podcast, but in my closings in the last, 3 years, I've really developed this whole chapter method for the past, because I always, you always like the future is worth way more, but obviously if it's not a wrongful death, because you so many more years and all that, you're going to ask for more for the future over a long period of time. But I started doing this chapters method where, like, I'll take, like in this case, the first 5 months were terrible. He couldn't walk. He was like having a major surgery, like couldn't get out of bed. And so I took all the damages, the non-economic damage list. We created 13 of them, like chronic physical pain, emotional pain, et cetera, just all those things that we actually tailor to our facts, which in California you're allowed to, your specific facts. It's not just always pain, suffering, emotional distress. You can tailor them. So we do that to our specific facts, sleep disturbance, whatever it may be. And then I'll break down like that worst chapter. I tell the jury, this is the worst chapter. He couldn't walk. He was in tremendous amount of pain. His mom had to help him go to the bathroom, like real bad stuff. And then, so that'll be the highest per hour per line. And so, but it's only 5 months. So I asked for $1,225 an hour for 5 months. And then the first chapter comes to $3 million. And then the next chapter, things get better because he's kind of on the mend, doesn't have CRPS diagnosis yet. And so the hours drop for each category. So it's all very fact specific. But then once he gets the CRPS diagnosis and he tries, lumbar sympathetic nerve block, ketamine, nothing works, then things start to go up again because it's bad. So it's all tied to the facts, and then the hourly is changing. And then for the future, I bring the hour per category way down. So it's like, $27 per hour, but it's over 28 years. And then that's kind of how I've started to do it lately. And I've noticed knock on wood, but I've noticed my past non-economic damage awards have gone up, more, and then it gives the jury a better framework. And I also think it helps protect the verdict for appeal because you're tying everything directly to the facts. So that's just one thing I've kind of been testing out lately, and it seems to be working.
Yeah, I've touched the chapter thing, not exactly like that, but more big picture. Like the book hasn't been written, here, and this is an important chapter. You're writing the next chapter in that sense. But I really like what you just did. I haven't done that. I might steal that from you. We can't do per diem in Illinois, but I don't see why you wouldn't be able to do chunks like you just described and recommend a total figure for chunks. We just can't break it down as granular as that to like a per hour or a per diem. We're not allowed.
So then how do you justify like the non-economic damages? Before, were you just typically 200 million or like just saying a number, or were you breaking it down at all?
So typically what I would do in closing argument is, certainly you go through the facts, make your arguments, and then when it's time to write a number, by then you've put an overall time on it. And sometimes there's a relationship. So, for the last 5 years, I'd suggest $2.5 million. Quick math in your head, that's $500,000 a year or something like that. For the next 38 years, I suggest $38 million. There's some case law in Illinois that suggests that you're kind of approaching the line of a per diem. So there's kind of strict contours on the prohibition on per diem, unfortunately. But even though it might sound like it's a little loosey-goosey compared to what you're describing, which I acknowledge that it is, I think the description of the injuries and the length of time that they suffer those injuries can still be very effective in justifying those big numbers. Another thing that's really important, that we have a great instruction. I think a lot of jurisdictions have this type of instruction. I'm pretty sure I checked at one point in California does too. You tell me, Dan. But it's an instruction that says that for future economic damages, you reduce them to present cash value, but for future non-economic damages, you do not reduce them to present cash value. And I spend a little time on that. And I show, assuming the judge allows me, I show this old picture of a McDonald's menu that's all grainy, and it's got cheeseburger for 25 cents. And man, I've had a couple of clients in the last couple of years where their life expectancy almost goes to 2,100. And so the year 2,100, right?
Wow.
For a birth injury case that we tried last year, for example. And so when you're talking about the year 2,100, and then you can say, think about what the value of the dollar was in 1950 when, a gallon of gas was a quarter stamp was 3 cents or whatever it was. And that can be very effective.
I do the exact same thing. I literally do. I have it where the years go up on a slide, and then all the way to this one was like 2053. And then I say to conceptualize how far back, and then the next slide, it goes down, and it went down to 28 years ago. And I have a picture of like Bill Clinton, Spice Girls, Palm Pilot.
Love that.
Exactly what you're saying. Because you got to it's hard for them to conceptualize the verdict for all time unless you put it in context to what they've already lived through and experienced, So I love that. Yeah, I do the exact same thing.
Yeah, that's a tough concept. I feel like I've dabbled in trying to bring that to voir dire. I'm open to any suggestion. That's a tough one, and it's probably just too premature. You can't really.
Yeah, one thing I'll throw out there, and I was just thinking about this, just talking to you guys, which is that's why I love these podcasts of coming up with ideas, talking to people who know what they're talking about is, but I think the idea that like, I could see somebody asking like, do you think that we used to undervalue the quality of life back in, 10 years ago, 20 years ago, 30 years ago? And I think your good jurors will be like, heck yeah. Like, and you could ask, do you think we still kind of do? Your good jurors will be like, yeah, we do. It's, there's nothing more valuable than quality of life. 50 years ago though, or 30 years ago, I think people didn't used to think that way. They were just like, your paycheck is what matters. Your house is what your assets matter more than your quality of life or your mental health and things like that. And so just introducing those qualities of like, what's it going to be like in the future? I think
especially mental health damages. All the mental health damages was like definitely 15 years ago. No one cared about, and that's totally changing. It's good. That's gonna be way more valuable, I bet, in the next 5-10 years.
Stress is the new like tobacco, probably.
Yeah.
In terms of your health and like what these plaintiffs go through, it's like, probably 30 years from now, doctors are going to be like, it was that stress over, this injury or whatever, if deployment case or whatever it is. That's what causes people.
It's funny you say that, because yesterday when I was going through the mental stuff, stress and how that affects the body, it was the young jurors were nodding along with me. And like the older ones were kind of just looking, like just staring. I don't know if they were bad or good, but the young ones were like absolutely nodding to the mental struggles of chronic pain. Which is
emotional distress.
Our young jurors they're very in tune with mental health. At least in LA, I don't know about other places, but you lose jurors for saying like, the subject of this triggers me, and I can't be a juror in this case. So
we had that happen in Harry and I tried a case in Santa Monica like 3 years ago or something, and there was like, I think it was a spinal injury or it was a wrist injury case. We had one of those models of a wrist bone, and it was like
that's right
underneath the counsel table. But you could barely see it. It was like kind of behind a box. And this juror's like, I'm just too triggered looking at that. I cannot sit to this. And it's like, oh my God.
Well, so I've got a kind of a funny story on that. We had a case that was, it was a back surgery. Well, it was a car crash where the lady had a T4 burst fracture. She had to have a pretty big thoracic surgery, 4-level fusion. And so we get through voir dire. We think we've got a good jury. There's this one guy amongst other good jurors that's, seems like a real nice guy. I think he was a public school teacher, just a friendly fellow. Right in the middle of opening statement, where we're showing one of the animations that, that shows an incision, just kind of showing a little bit of what the evidence is going to be. The guy starts, he's got his pad, he's writing, he starts going like this. All the blood drains from his face. He looks white as a ghost. And then finally, he looks like he's sweating. I can see the shine on his forehead. He raises his hand. He's like, Your Honor, I need a break. And we take a break, and he comes up. He's like, Your Honor, I almost passed out. I cannot handle images like that. So if there's going to be a lot of that, I cannot sit on this jury. And we loved him. And he's standing right there. And I think, before we started talking about him, we excused him. And the judge looks at me like, well, what do you want to do? I don't know if you saw that. I was like, yeah, I saw it. I couldn't object to that, right? I wasn't like, no, he's got to stay. And so, I agree. He comes back in, he's excused, we've got alternates, so we're fine. He said on his, kind of before he left, he's like, I'm sorry, if anybody would have asked, I would have told you, because this isn't the first time I've had this reaction. I thought, maybe I should have asked. And I was like, No. I don't want to ask. I don't want to, we may have lost him, but what if we lost like 2 or 3 others? So I know sometimes plaintiff jurors ask about, you're going to see graphic, kind of prepare them for that. I'd like to hear your guys' thought. I don't think you do, because I think you might lose someone who they can handle it, but they see an out or they're being overly cautious and they're like, yeah, I don't like that. I'd rather not be on this jury.
That's a really good point. I've actually never, I mean, I'm sure Harry picks a lot more juries than either of us combined, but yeah, I've never brought that up. Harry?
I've seen defense do it if they're smart. I've seen defense in like a sexual abuse case I remember one time they were just like throwing out like the most graphic terms just to see who's uncomfortable with that, because they knew that the really sensitive jurors are not ones that they liked. So on the plaintiff side, I wouldn't do that. I want to get rid of. You're really getting rid of. I mean, the people that are worse for you, the people who are like, I don't care. You show me anything, I'm not going to bat an eye. So, I think you just get through it. I remember recently, I think it might have been that Starbucks case. I think Nick Rowley, either that one or the one in New Mexico. He told the jurors, like, I think a juror said, I don't know if I could look at pictures of, injuries to somebody's, genitals. And he was like, I don't think we need to show it. He's like, does anyone feel like you need to see those photos? And this is during jury selection. And they're like, no. He's like, okay, we're not going to show it, which was fine. Like we didn't, so I think it's worth keeping those good jurors and maybe not showing them things that can be described to them. But I know in some cases you can't do that. Yeah.
Well, I like the mystery in that too. I mean, that's like, that creates their imagination is just going to go nuts. I mean, no pun intended.
Yeah. Well, I mean, that's a tough call, right? Because those pictures can be incredibly powerful. Yeah. My curiosity there was that an on-the-fly decision, or had that been decided already, or maybe they had been eliminated out already, or
no, I don't. They hadn't been eliminated out. I don't know. I can't speak for Nick if that was something he had planned or something that just happened in the moment. It seemed like it happened in the moment. So,
how bad were did you see were the picture maybe
They're
not
pretty bad, but I mean, people could describe them too. Yeah.
Okay. So
I mean, it's what you would expect. I mean, but I think I think your reaction was right, Dan. I think like people's imagination is always worse, if not the same. I mean, seeing something like that, you're like, that's what I expected. That doesn't really move the needle, though.
It's funny, Harry. I'm still in the middle. I'm still in this 4-week trial, I guess you could say. But that one juror who said about he saw the client walk in and out and that he'd have trouble. I actually think it seems like he's with us, but every time I'd put up like this photos of like the staples and the scarring, and it looks pretty nasty, like in his dislocated ankle and all that, he would always like turn away. Like he couldn't look at it even like every time. And then in my closing, he just like kept turning away. So it's interesting. I wonder how that'll impact how he, thinks about the damages. I don't know yet. I'll find out soon. But
he obviously finds it shocking and upsetting. Yeah. He's not gonna, he's not like a big deal. So
I imagine, Patrick, I mean, you must have, and we'll wrap up here soon, but you have horrific imaging. I mean, are you showing it frequently? Are you showing it just one time? What's kind of your philosophy?
Yeah. So we had a case recently we tried in December where one of the issues was the survival act, so conscious pain and suffering. And the pictures from the autopsy, and this was another case that involved a young person, just a horribly sad case, one of those cases that are really just tough to get through. We kind of had to show them. It was important for the elements of damages, and there was a fight. Of course, there was a legal fight, and we won. But to answer your question, Dan, they're going to pick up on it real quick if it looks like you're trying to play on their sympathies, show it to them too much. So, we would put it up. It would be up briefly. We would bring it down. Obviously, never when the parents were in the room. And so we've got to be very tasteful. That's very important.
I totally agree. I mean, not only trying to play the sympathy, but desensitizing like you talked about.
That too.
It's power in seeing it once, and I think that'll stick in people's minds. So, all right. Well, with that, this has been an awesome episode, man. I really appreciate it. We didn't even mention that you're a fellow Buffalo. We graduated the same year in Boulder. Unfortunately, we didn't get to party together there, or maybe we did. And we don't. Maybe we did. And we don't remember. I don't know. Who knows? But yeah, man. Thank you so much. You're doing fantastic work. I can't wait to hear about more 8- and 9-figure verdicts coming out of your office and you. And so, thank you so much. This has been great. I want to thank our sponsors again. Want to thank Law Pods for making all this possible and providing these forums for education to make plaintiff's bar that much better. So thank you so much, Harry. I'll see you in the courtroom soon, probably. Patrick, I hope to see you in Chicago one day. when I
That'd
come
be
out
great. Dan and Harry, thank you so much for having me on. And Dan, good luck.
Thanks,
There's
buddy.
nothing like waiting for a verdict. So I can
It's the
imagine
worst.
maybe this was a little respite from that stress to take your mind off it for a little over an hour. But good luck, man.
Yeah, thanks, buddy. I appreciate it. All right, guys.
All right. Thanks, guys.
If you're enjoying the podcast, the best compliment you can give us is sharing it with a colleague who would find it valuable. For all the best clips from the podcast, follow us on social media. You can find those links in the show notes. Have a jury selection story to share? Email us at podcast@pickingjustice.com, and we may address it in a future episode. Until next time, remember, you're not just picking a jury, you're picking justice. Produced and powered by Law Pods.